Now we see it.
Okay, great. Can you hear me?
And we can hear you.
Okay.
Fantastic.
Good afternoon, everyone. And my name is Johnnie Barton. I'm Chief Counsel with the Office of Open Government. And thank you, Director Allen. Thank you for coming to attend this training on the Open Meetings Act for Board of Trustees of Public Charter School Boards. This training takes into account that you are already familiar with the OMA. We will go over some aspects of it, but others we're just going to look at closely, not so closely, I should say, and we're going to look at some best practices so that you as members of public bodies can best ensure your compliance with the Open Meetings Act. And if you have some questions, please feel free to ask. The OOG's mission, and that's the Office of Open Government, is to ensure that operations at every level are transparent, open to the public, and promote civic engagement. What is a meeting under the OMA? A meeting is a gathering of the quorum of the members of a public body. The members of the public body consider, conduct, or advise on public business. Public business includes gathering information, taking testimony, discussing, deliberating, recommending, and voting. And these gatherings may be held in various ways: in person, remotely, by telephone conference, video conference, or by other electronic means of communication. I'm hearing a little feedback. Can you make sure that you're muted if you're on? Thanks. So one of the things that we have to know is our number, and our number being what is a quorum. It's usually established by your bylaws or your articles of incorporation. If there are none, it's stated. If none is stated, it's a quorum is half plus one, or a simple majority.
And I'm sorry, Mr. Barton. Yeah, so if you're on the phone and you want to mute, if you hit *6, I think that'll do the trick. Phone number ending in 50. Thank you.
Thank you, Nicholas. Well, open meetings. A public body's meetings must be open to the public unless the OMA permits closure, and we'll go into that a little bit later, the reasons for going into closure. A meeting is open to the public if the public is permitted to be physically present. News media is permitted to be physically present. The meeting is televised, and under current emergency and temporary legislation, when the public body takes steps reasonably calculated to allow the public to view or hear the meeting while the meeting is taking place, or if doing so is not technologically feasible, as soon thereafter as reasonably practical. During this emergency and temporary legislation, while it's in effect, the physical posting requirement at the office where the public body meets or at a place for the public to view is waived, and these provisions are good through December 31st, 2023. Notice, under the Open Meeting Act, before a public body can meet, it has to provide notice to the public of its meeting. And those provisions are found in DC Official Code 2-576. The notice requirements are as early as possible, but notice must be given at least 48 hours or 2 business days before each meeting, whichever is greater before the meeting. Again, the physical posting requirement is waived right now. Notice must be posted on the website of the public body or the District of Columbia. The Public Charter School Board of Trustees meetings do not require publication in the DC Government Register as other public bodies do. All right, I'm going to show us a notice of a public meeting, and we're going to figure out whether this public meeting notice complies with the OMA. The Board of Trustees of ABC Public Charter School Board will hold a meeting at 12 p.m. Due to the continuing public health crisis, the board will meet remotely. Below is a draft agenda for the meeting. A final meeting agenda will be posted on the board's website at abcboard.org. The rest of the notice, members of the public are welcome to observe the meeting. In order to register for and attend the meeting, please visit these particular sites and use this event number or use the phone numbers listed. And I want us to mentally remember what we just saw. And I want to ask you, based on your knowledge of the OMA, is anything wrong with that meeting notice? Does it comply with the OMA or is it deficient? And we've got some choices that we're going to look at. A, the notice complies to the OMA, is short and to the point, easy to follow and understand. B, the notice only lacks a draft meeting agenda, otherwise it's fine. C, the notice lacks the date, a draft meeting agenda, and notice of intent to enter closed session if applicable, and the notification that this meeting is governed by the Open Meetings Act. Please address any concerns or any questions or complaints arising under this meeting to the Office of Open Government at opengovoffice@dc.gov. So those are your three choices. And I'll go back and let you take another quick look at the notice. And those are our choices. And if you can mentally make your selection, we'll move on and find out which answer is correct and why. C is the correct answer. The notice must include the time, date, location, and proposed agenda. The date rather was missing from our mock agenda, as well as a proposed or draft meeting agenda. And it also must contain the link, telephone number, or other means for the public to attend the remote meeting. If there will be a closed session, notice must include the OMA citation from DC Official Code 2-575B and state the reason justifying the closure. DC Official Code Section 2-576.5. This was also missing from our mock meeting notice. All meeting agendas, whether the draft or final, must include this statement at the end. This meeting is governed by the Open Meetings Act. Please address any questions or complaints arising in this meeting to the Office of Open Government at open-dc.gov. And I'm mistaken, that was on our mock meeting notice. So the meeting notice was deficient because it didn't contain the time, and it also did not contain a draft meeting agenda. And both of those are required under the OMA. We need a little help from you all. Our job here is to help you to comply with the OMA. And in order for us to do that, we need some assistance from you. And here's how you can help us. I'm sure that each of your Board of Trustees has someone we like to call the Administrative Point of Contact, or APOC. And that's the person who we can contact in the event that your meeting notice is not where it should be. I mean, it's missing totally, or if it's incorrect. But in order for us to do so, we need the current information so that we can either put it on our website and have it, or it needs to be on your website. But at any rate, we need that information. And here's an example as to why. So it's 72 hours and 3 business days before the meeting. Remember, at best, you have to give 48 hours or 2 business days, whichever is greater before the meeting occurs, notice to the public in order to have a meeting. So we got 72 hours and 3 business days. And that's great time. OOG staff looks on the central meeting calendar, and we'll go into detail a little bit later about what that is. That's a calendar we maintain with public bodies, some public bodies post their meeting notices and their meeting records to. Board of Trustees of public charter school boards are welcome to use it as well, and we'll provide some information later as to how to do so. And the Board of Trustees for ABC Public Charter Schools website for its APOC's contact information to let them know that the remote meeting notice lacks the time and agenda for the public to attend. However, the listed information is for someone no longer with the entity. There are no responses for 2 days. So we've gone from 72 hours to 24 hours. And we've tried our best to contact this person, but we don't have the updated information. At that point, you can't conduct the meeting under the OMA because you haven't given adequate notice. So it's very important that we have your administrative point of contacts information and that is accurate. If you get a new one, that we have that information so that we can contact that person in the event that there is an issue, so that you won't be, so you'll be able to conduct your business. This is what the central meeting calendar looks like. As you see, it has a listing for Apple Tree Early Learning Public Charter School. It has the point of contact. It has their phone number and it has their email address. If there were a meeting occurring in November, that meeting would be populated somewhere on the calendar. And once you click on it, it would give you the agenda and all the particulars about the meeting. So this is an example of what it would look like. The OOG's central meeting calendar lists your administrative points of contact's name, telephone number, and email address. Again, it is crucial that the APOC's information is current on the central meeting calendar and or your website. In our scenario, if the information was correct and the OOG was able to contact the APOC in time, corrections to the meeting notice would allow the meeting to proceed without any issue. So we have our first best practice tip. Please update your APOC's information with the OOG and on your website. Please make sure we have it. Even if you don't publish on the central meeting calendar, we can still list that information and we can have it available for us in the event that we need to use it and if we can't locate it on your website. How much public notice of meetings is required? Again, 48 hours or 2 business days. And this was a question that somehow the slides somehow got out of the way. But how much public notice of meetings is required? 48 hours or 2 business days, whichever is greater before the meeting. 78 hours or 3 business days, whichever is greater before the meeting. As much notice as possible, but not less than 48 hours or 2 business days, whichever is greater before the meeting. So, give you an opportunity to make your mental selection. How much notice is necessary? Notice meets the letter of the law. And what I mean by the letter of the law, you meet the law if it is not less than 48 hours or 2 business days, whichever is greater before the meeting. So A is correct, but C is also correct. And let's go back and look at why. You meet the letter of the law if you selected A, which is a good thing, but a better thing is to give as much notice as possible. And why is that? If you give as much notice as possible, and say you give a week's notice, and there is an issue again with your notice, we can correct it, cure it, and you can go on with your meeting. If you give 48-hour notice and we don't catch it until the day before, 24 hours, then there's a problem with you conducting the meeting. So while A is correct, B is the the better answer, C is the better answer rather, and give as much notice as possible if you can, but not less than 48 hours or 2 business days, whichever is greater before. This leads us to what I call the overlooked language in the OMA. Except for emergency meetings, a public body shall provide notice as early as possible. And again, and I have to confess and tell on myself, our time is due today. I haven't put my time in yet. I want to get paid when it's time to get paid. I have a tendency to wait a little bit. If there's a power outage and the computer goes out and I'm not able to use my cell phone, then I'll wind up short because I've waited to the last minute. Am I in compliance? Yes. But I run into problems sometimes if you wait too late. And the same can be true with us and the OMA. So I'll be sure, Director Allen, as soon as the training is over, to get my time in as requested. Try to do a little better next time. Again, build in some cushion in case there's an issue with your notice. Best practice tip number 2, notice the public as early as possible. And for the reasons just stated, you want to give the public as much notice as possible. Be careful if you recycle. Now, recycling is usually a good thing. You know, I get a lot of, I get plastic water bottles. I buy my water in the plastic water bottles from Costco, the 48, 24 in a container. And I like to recycle them. You know, I like to help the environment. But we have to be careful if we recycle under the OMA. And what I mean by recycling under the OMA is our meeting notices. One of the things that comes up periodically is that a public body has taken a past meeting notice and has made some, but not all the changes to its to reflect its current meeting. And the meeting notice winds up deficient. It can have the date, it can have the right time, but the wrong date. It can have the wrong access information. It can have the wrong reasons for entering into a closed session that were good on a previous notice, but are not good on a current notice. So you want to be careful that if you are reusing an old meeting notice and just going through to change the relevant information, that you make sure that it's up to date, and that if you're recycling, that all the information is that reflects what is going to be on the current meeting and not something that has already transpired. So when reusing an old meeting notice, be sure to update the date, time, meeting link, or dial-in number, the reasons for going into closure, and the corresponding citations. Again, failure to do so may result in the inability to conduct the meeting. Best practice tip number 3, be sure to update a reuse meeting notice. Again, for all the reasons that we've just stated. And I'm going to pause and see if there are any questions right now. Rick Allen, do you see any questions in the chat?
There's one, Mr. Barton. I think around slide 24 or so, you had something about 3 days and 72 hours. And it looks like, yeah, maybe slide 23 there. Yeah.
Yeah, this was a question. This was a question.
Yeah. Okay. Sorry.
No worries. What is the proper notice? And again, the proper notice is number either A, if you're following the letter of the law.
Actually, Johnny, I think that question was referring to a prior slide that talked to the issue of public notice. And I just want to confirm information that I saw in a prior slide regarding that. I thought I saw earlier 72 hours and 3 business days, but I might have misread something in a prior slide regarding that.
That was one of our illustrations, and I'll go back to it and we'll go over it. this is the illustration. So the illustration was it's 72 hours and 3 business days before the meeting. So this is when the notice is posted.
Okay.
Uh,
Okay. Well,
So
I guess I saw this message, the 72 hours and 3 days. I guess I assumed that was that was the note that you wanted us to capture here. And then when I saw the question later on, it conflicted with it. So okay, so I might have just interpreted this slide incorrectly compared to the question, which we're trying to get at with this particular notification information.
I'll go over it again just to clarify. So this is a mock notice, and the notice was posted 72 hours or 3 business days before the meeting, which in most cases is fine. However, there's a problem with the notice, and our office attempted to contact the administrative point of contact for two days and was unable to do so. So we've gone now from 72 hours to 24 hours. And unfortunately, 24 hours is not enough notice under the OMA for the meeting to occur and proper notice to the public.
Gotcha. Thank you. I thought I saw that earlier. I just wanted to make sure that wasn't the actual note you were trying to make sure that we kept from that.
So we'll go to the next slide just to clarify how much public notice of meetings is required. A, 48 hours or 2 business days, whichever is greater before the meeting. That is absolutely correct. That is the letter of the law. B, 72 hours or 3 business days, whichever is greater before the meeting. Yeah, I mean this could actually work, but under the OMA, what the statute says is as much notice as possible, but not less than 48 hours or 2 business days, whichever is greater before the meeting. So A and B are absolutely correct. If you look at the language of the OMA, 72 hours and 3 business days wouldn't be wrong because that's more notice than is required. So, but the letter of the law is 48 hours or 2 business days, and C as much notice as possible. And I see where the confusion has come in, so I'll note that for additional training to kind of modify that slide. So thank you so much for your question and for your clarification there. Meeting minutes, transcripts, or recordings. What does the OMA require? So one of the things that the OMA does require is that records are kept of the meetings of public bodies. And we're going to look at what is actually required and what is maybe optional. All meetings must be recorded by electronic means, and that's whether the meeting is open or closed. So all meetings must be recorded by electronic means, whether it's a digital tape recorder, whether it's recorded online through Teams or WebEx, whether it's done on a cell phone. It has to be recorded by electronic means. Electronic, if it is impractical, if for some reason that you cannot record the meeting electronically, then you may take detailed meeting minutes, DC Official Code 2-578. What are detailed meeting minutes? Detailed meeting minutes are more than just bullet points. It's enough clarity for someone who did not attend the meeting to be able to look at it and understand what took place. So if someone were to look at it a week later, they would be able to understand what took place at the meeting, even though they weren't there. The meeting minutes have to be detailed in the event that you cannot make an electronic recording. The recording is mandatory. The meeting minutes and the OMA also talks about transcripts are not. However, some public bodies do both electronic recording and meeting minutes or transcripts. If a public body does do transcripts, we ask that they check with their vendor to make sure that if they would like to publish them, that there's no copyright or other issues with them publishing the transcript. And what we mean by transcript is like a court stenographer type, where it's verbatim word for word. The OG has opined that you should post the recording to your website if you have the capacity to do so. Otherwise, the recording should be made available upon request to the public. So if you don't have the capacity on your server to post the recording, it should be made available upon request to the public. In both instances, you must do so within 7 business days of the meeting. And please disregard this last bullet point. That doesn't apply to public charter school boards of trustees because you are not subject to DC's FOIA. Publication. A copy of the meeting minutes, the draft meeting minutes of the meetings of public charter school board of trustees should be made available no later than 30 days after the meeting. So and that's because we understand, and the council understood when it crafted this legislation, that your meeting minutes are not going to be approved until the next regular scheduled meeting of the public body. So you have 30 days, to basically approve those meeting minutes and have them posted. A copy of the full record, including any record or transcript, should be made available for public inspection as soon as practicable, but not later than 7 business days after the meeting. That's found in DC Official Code 2-578B. So best practice tip number 4, post your electronic recording, detailed meeting minutes or transcript to your website. That's if your server has the capacity to do so. If not, make them available to the public. One of the things that we advise is if you don't have the server capacity, that you have them, downloaded on a separate hard drive, but the means to readily retrieve them and get them to the public once the public requests the meeting minutes. Under the OMA, a public body can have, and this includes a board of trustees of public charter schools, an emergency meeting. And we're going to look at what's required for an emergency meeting in as far as the notice requirement. So under the OMA, you absolutely can have an emergency meeting. And by emergency, we mean something that's pretty serious. It affects health, safety, and welfare. We have an advisory opinion that goes into detail as to what is an emergency. So if a public body wants to conduct an emergency meeting, what kind of notice do they have to give the public? Response A, you may conduct an emergency meeting without providing notice to the public. B, by providing the public the same notice as non-emergency meetings. Or C, providing notice to the public at the same time notice is given to members of the public body. So there's a different notice requirement for emergency meetings. And, here are the choices that you have to select from in order to kind of figure out which one is correct. We'll go through them, but there's your A, B, and C. I ask that you make a selection and we'll the right answer. C is the correct answer. So if you want to have an emergency meeting, you don't have to give 48 hours or 2 business days notice to the public. You don't have to give you don't have to give the same notice as a regular meeting. But you have to provide notice to the public at the same time notice is given to members of the public body. The notice may be given by physical posting if that provision is in place in the office of the public body or a location convenient to the public. But again, that provision is being waived right now until December of 2023 because a lot of the meetings are taking place remotely. Or it can be on the public body's website or the district government's website, which is the central meeting calendar. So the notice provision is as pretty much as much notice as you can give under the circumstances for legitimate emergency. And the notice has to be given at the same time to the public that the members of the Board of Trustees of the Public Charter School Board receive their notice. That's found in DC Official Code 2-576. Use a transcript or a transition script. What we mean by a transition script is basically a script that's written already in advance that tracks the language of the OMA for an emergency meeting or to move from an open meeting to a closed meeting. So to ensure OMA compliance, we recommend that you provide the chair with a script that lists the protocol to transition from an open to a closed session and for emergency meetings. And we are happy to assist with the script, to review it in advance, and to ensure that it complies with the OMA and to give you guidance in that regard. So best practice tip number 5 is prepare scripts for emergency meetings and entering closed sessions. This will ensure, again, that there's compliance with the letter of the law, which is necessary for both going into a closed session and for conducting an emergency meeting. So we've got a what if scenario. The Board of Trustees of ABC Public Charter School frequently enters closed session to discuss matters concerning student PII or personally identifiable information, and when meeting with the staff of an eligible chartering authority for the purpose of being evaluated by the eligible chartering authority. When doing so, its meeting notice properly cites the OMA and provides a description of the reason for ending closure. So we've got a Board of Trustees that goes into a closed session, usually to discuss matters involving student PII or when being evaluated by an eligible chartering authority. On its November 19th, 2022 public meeting notice, the Board of Trustees properly cites the OMA with a description of one of the 2 reasons it normally enters a closed session. So they've listed student PII, but they've left off eligible chartering authority. While in closed session, the board chair realizes they need to discuss the other matter that's been left off the agenda. Normally, that would be a proper subject to discuss in the closed session. It was one of the 2 matters the board or the public body normally discusses in closed session. Question is, can they discuss this matter? So they have listed one of the 2 reasons on their agenda for going into a closed session. But while in the closed session, they realize, hey, we need to discuss this other matter that's not listed on their agenda or of which the public didn't have advance notice. They were going to enter into a closed session. The question is, can they enter into the closed session to discuss the additional matter? And here are our responses to choose from. Yes, because it is a proper matter to be discussed in a closed session. B, no, because the statement of intent to close the meeting did not include the citation to the reason for closure under 2-575B and a description of the matter. Yes, because it is important. It is an important matter that must be discussed. There are your choices, A, B, and C. Give you a moment to ponder those. And we will make our selection. B is the correct response. Best practice tip number 6 is to include in your notice of intent of the OMA citations and the description of matters that you normally or may have to discuss in closed session. What we are advising is it's better to have it listed and not need it than not listed and then need it. So if your public body or if your board of trustees in this instance usually goes into a closed session for, we'll look at the 2 reasons that they normally go into under the two, I should say the 2 provisions of the code that are specifically for DC Public Charter School Board of Trustees. They normally go into a closed session for both of those reasons, then you are absolutely within the law to have those listed on your agenda, even if you don't go into closure. It's a notice of intent. So you give the public the notice that you may have to. So it's better to have it listed and not have to go into a closed session than not have it listed, and then you need to discuss it in the closed session. Because if it's not noticed, you're not able to discuss it, even if it's a valid reason under the OMA. The protocol for emergency meetings. When an emergency meeting is convened, the presiding officer shall open the meeting with a statement explaining the subject of the meeting, the nature of the emergency, and how public notice was provided. Remember when I talked about providing a script? This is what we're talking about. Simply track the language from the code, DC Code 2-577D, because the presiding officer is going to say what the emergency is, the subject of the meeting, and the nature of the emergency, and how public notice was provided. Provide that to them in a script, and they'll be in compliance with the OMA protocol for entering into an emergency meeting. To enter a closed meeting, DC Official Code 2-575C provides that before a meeting or portion of a meeting may be closed, the public body shall meet in public session at which a majority of the members of the public body present vote in favor of closure. The presiding officer shall make a statement providing the reason for closure, including the citations from subsection B, and that's DC Code 2-575B, and the subject to be discussed. The OMA also requires that a copy of the roll call vote and the statement shall be provided in writing and made available to the public. So again, provide a script. The script is going to provide the presiding officer with the statement that he or she will make concerning the reason for closure, including the citation from DC Official Code 2-575B, and the subject matters to be discussed. Notice requirement for closed meetings. These are a list of, I believe, some, if not all, of the reasons for going into a closed session. I believe there are currently now 16 or 17. But court order or statute, certain contract negotiations, attorney-client privilege, and this means doesn't mean that an attorney is simply present, but that the attorney is actually going to be giving legal advice to the board, who is his or her or their client. Certain trade secrets, testing and grading, personnel and disciplinary reasons, training, collective bargaining negotiations, deliberations. Some public bodies sit as a quasi-judicial public body, almost like I call it a mini court. And when they deliberate, they can deliberate in closed session. Public safety, investigations of a civil or criminal matter if word of the investigation would compromise it. And these are the two provisions specifically carved out for Board of Trustees of Public Charter Schools. Student PII, or Student Personally Identifiable Information, where that's discussed, and Charter Authority evaluations, and we'll take a look at each one. And this is DC Official Code 2-575B15 to discuss matters involving personally identifiable information of students. Again, you can go into a closed session using this provision when you have to discuss matters involving personally identifying information of students. Provision subsection 16A, the public body is the Board of Trustees for a public charter school to meet with the staff of an eligible chartering authority for the purpose of being evaluated by the eligible chartering authority. Again, you can cite this provision, 16A, evaluation by a chartering authority. But there is some limitations on this. Subparagraph B states, it shall not be construed, that A shall not be construed, permit the Board of Trustees to close a meeting that will otherwise be open merely because the staff of an eligible chartering authority is participating. So it has to be where there is the, you're being evaluated, and not simply because a member of an eligible chartering authority is participating or is present. Descriptions of matters to be discussed in closed session. Less is better. Board of Trustees of ABC Public Charter School must go into a closed session to discuss matters that include student personally identifiable information. The notice of intent to enter closure states, pursuant to DC Official Code Section 2-575B15, to discuss matters concerning the following students: Peter Pan, and it lists his social security number, and Robin Hood, and it lists her social security number. That's unnecessary under the OMA. Less is better. Remember, you're going into closure for the purpose of discussing student PII. So on your notice, you don't want to list who the students are or their social security numbers. It's enough to just list, pursuant to DC Official Code 2-575B15, B15, to discuss student matters that involve student personally identifiable information. And the OOG has an opinion that descriptions of a general nature satisfy the notice requirements under DC Official Code Section 2-575C1 and 2-5765. So the description is less is better. Our best practice tip number 7. Under the OMA, the description of matters to be discussed in closed session can be general and should be general and not too specific as the examples that we just saw. I'm going to check with Attorney Well to see if there are any questions in the chat, or if anyone on the meeting has any questions.
We've got a can meetings. Oh, well, if oh, sorry, I think we're caught up. We're caught up.
So if not, at the end, we'll take any questions that haven't been answered.
No, a question just popped up a few seconds ago.
Oh yeah, okay, from Ms. Cheatham. So if a board were receiving legal advice, what level of specificity would be appropriate there? I'm assuming in the announcement to go into reason for closure.
To receive legal advice from their attorney, that's sufficient enough. You don't have to go into any specificity about the issue. To receive legal advice from the attorney about the contract that's pending, just to receive legal advice is sufficient. Less is better and less is appropriate under the OMA. You don't have to go into any specificity. And again, we want to make sure that in giving our notice, we're not kind of letting the public know the reason, the specifics of the reasons that we're going into closure. So that would defeat the purpose. So less is better. We simply state when Bega goes into its meetings to receive advice from its attorney. That would be sufficient information. Okay, what if there's a quorum at a holiday gathering? We know that a quorum is the magic number for what can constitute a meeting. If we have a quorum and there's discussion of public business, then it's a meeting subject to the OMA. But what if there's a quorum at a holiday gathering? The OMA defines a meeting as any gathering of a quorum of the members of a public body, including hearings and roundtables, whether formal or informal, regular, special, or emergency, at which the members consider, conduct, or advise on public business. It also states that a meeting is not a chance or social gathering. So if a quorum of the members of a public charter school board of trustees happen to wind up at the same holiday gathering, it's a chance encounter. It's not something they plan to do, and there is no discussion of public business. It's not a meeting under the OMA. I think our next practice tip is going to be that we remind our board members around the holiday time, especially, but all times, that if they do gather as a quorum, they do find themselves in that situation where there's a quorum. Don't even mention any business. Don't discuss any type of the board's business, because again, that could be a meeting under the OMA and be a violation. So it's not provided that it is not held to avoid provisions of the OMA. Of course, if a board decided that they were going to meet at a local restaurant for the purpose of conducting a meeting, then that's a violation, and that's a meeting under the OMA. Best practice tip number 8, remind your board members to avoid any discussions of public business when a quorum is present at social gatherings or chance encounters. And again, we are here to help you, and we are listening. During OMA trainings, some public bodies have requested a specific training. Some board of trustees may require us to come in and do a training when they get new board members, which we highly recommend. There may be some issue that is a sticking issue with a compliance matter that you as a administrative point of contact, or you as a board member have noticed, and you want us to address it. We will tactfully stress any areas of concern you tell us about, without ratting you out. We'll just, make a note to stress it and to make sure that it addresses any concerns that you have. One of the things that we also currently do, and don't get shocked or don't think there's something wrong if you find a member of the legal staff attending one of your board meetings. We monitor the meetings, again, for a couple purposes. Number one, to see that while we're there, if there are any questions or concerns that pop up, we're there to give spot advice, ask. We also want to ensure that the public has, access to meetings, and if there is not an issue with, if there is an issue with access, that the public body does what is required of the law with getting the remote electronic recording available as soon as practical. So best practice tip number 9, let us know any specific areas of concern or issues that need emphasis, and we'll do it during our training. Because a lot, as far as say the majority of the meetings that are being held right now by public bodies are electronic meetings, we have some advice that we like to pass on to public bodies, particularly those who are going into an executive or closed session during the meeting. If the meeting is remote, the OG recommends that the public body have 2 separate online meeting links. Remember that a roll call vote for an executive or closed session is needed in the public meeting before closing the meeting to members only. The public meeting must continue for the duration of the executive or closed session. And once the executive or closed session ends, the public body must re-enter the public meeting and report only where appropriate, and then adjourn the meeting. We also recommend that you test the meeting platform near the meeting time to ensure it is accessible to the public body members and the public. And what happened today was a classic example of it. Sometimes things happen with technology. In this instance, we were able to correct it and able to go on with the training. So we highly recommend that you, when possible, test your platform near the meeting time to ensure that it's working, number one, for the members and also for the public. And also something I left out with emergency meetings, during electronic meetings. Again, the electronic meeting has to be recorded by electronic means. All the votes should be taken by roll call, and all the other provisions of the OMA are also applicable. I think this brings us to the end of our presentation. I want to reintroduce to some and introduce to others our staff. The Director of Open Government is Niquelle Allen, and that is her contact information. I'm Chief Counsel Barton. There is my information. We have currently 2 attorney advisors. Cherie DeBerry, it's her information. Our trial attorney is Nicholas Well, and that is his contact information. Our IT specialist, this is the individual that if your public body wants to, excuse me, published on the central meeting calendar, Mr. Bridges is the person that you're going to contact. He's going to provide you with credentials and instructions on how to post your meeting minutes and your notices on the central meeting calendar. So that is his contact information. And our paralegal specialist, Kimberly Brown, that is her contact information. Again, I want to take this opportunity on behalf of Director Allen and the Office of Open Government to thank you all for attending this training. We'll make the slides available from both the earlier training today that Attorney Nicholas Weil conducted, and this training as well. And if there are any questions, we're happy to try to address them at this time.
Lots of thank yous, but no additional questions unless people are tapping away.
And we'll give you a couple minutes in case someone's putting something in the chat. But again, we want to thank you, and feel free to contact us. We're here to help. Yes, we are an enforcement body, but we want to do everything that we can to avoid, court litigation or that sort of enforcement. But if it comes to that, we do that. But please contact us with any questions or concerns, and we will address them as quickly as we can. If there are no other questions, again, we thank you so much, and we'll have some other trainings coming up in the future, including one I know on parliamentary procedure. And under the OMA, public bodies are free to use parliamentary procedure when conducting their business. And that training will go in detail on, I just saw a question pop up, disappeared. Hey, can you check and see if there's anything? I thought I saw one.
We have an additional name for the distribution list. Oh, and there's a question, were there any changes to the OMA? You mean like Taurus malls, you mean like amendments? Yes.
Well,
What news of amendments, Mr. Barton?
okay, well, there's emergency and temporary legislation, other than the provision that now puts Board of Trustees under public charter public charter school boards under the OMA. There's emergency and temporary legislation that redefines open meeting to include a remote meeting if a public body takes all the necessary steps to allow the public to attend remotely, and if that technology fails, the public body makes the meeting recording available to the public as soon as possible, and the requirement of physical posting of meeting notices is waived. Both provisions have been waived until December 31st, 2023. Attorney Wow has brought to our attention also that there is a new provision in the criminal code that makes it a misdemeanor. If I'm correct, Nick, please correct me if I'm wrong. For someone to to purposely disrupt the meeting of a public body. So that's not under the
Significantly disrupt.
significant disrupt, and that's not under the OMA per se, but something that has impact on public meetings.
And it still has to go through mayoral and congressional review and so forth. So it's not in there yet, but we're keeping an eye on it.
Pending. So there are no other questions. Again, I want to thank you all. I want to thank OG staff for attending, and we appreciate your attention, and we hope to see you soon at some upcoming trainings. And again, if you have any questions in the interim, feel free to email any of us, and we'll get a quick response back to you. So thanks again. Please enjoy the rest of your day, and we appreciate so much your attendance and your time today. Goodbye, everyone.